and welcome to Daily News Simplified, the why, what and how of newspaper reading. Today we will discuss the articles displayed on the screen from the Delhi edition of The Hindu newspaper dated 29th November 2018. So let's start our discussion. Now this article on page number 9 is related to the issue of Sentinelese tribes in the Andaman and Nicobar Island. So the author states that implementation of various provisions to protect the tribals of Andaman and Nicobar Islands has been poor. So in this article, the author has highlighted the various policy measures that have been taken to protect the Andaman and Nicobar tribes and how the implementation of such policy measures has been poor. And previously, if you notice, in the year 2014, 15 and 17, there were questions related to the tribes or the scheduled tribes. In this regard, if you note that in the year 2014, there was a question related to major provisions in the Indian Constitution for the upliftment of scheduled tribes. Further, in the year 2015, there was a question related to positive sex ratio in the tribes of India as compared to that of scheduled castes. Further, in the year 2017, there was a question related to major legal initiatives by the state since independence addressing the discrimination against scheduled tribes. So that is why all the policy measures that have been taken by the government with regard to the Andaman and Nicobar Island tribes are important for us from exam point of view. Further, there has been issue in the implementation of these policy measures. Now, these questions have been asked in the General Studies paper 1 of the mains examination. So that is why all the points that have been mentioned by the author in this article are important for us from exam point of view, and a question can appear in the General Studies paper 1 related to this issue. Now, the author highlights the names of various tribes of Andaman and Nicobar, and in this regard he has highlighted the names of the Great Andamanis, the Onge tribes, the Jarawas and the Sentinelese, and all these tribes belong to the Negrito tribal community. Further, he highlights that there are two tribal communities which belong to the Mongolod tribal communities, and these are the Shompen and the Nicobaris. Now, in this regard, the author has highlighted that except the Nicobaris tribe, the population of other tribes have reduced drastically over the decades. So in this regard, let us look at India's policy towards tribals. So in this first, we will look at Jawaharlal Nehru's tribal Panchsheel policy towards the tribals. So in this regard, the first principle was non-imposition. Now, this principle states that people should develop along the lines of their own genius and the imposition of alien values should be avoided. So, in this regard, you should note that various tribal communities have been living a relatively isolated life. So, that is why the policy was to let them develop along the lines of their own genius or their own values. And the values of the mainstream communities should not be imposed on these tribal communities. The second aspect of this tribal Panchsheel includes that tribal rights in lands and forests should be respected. And we know that most of the tribal communities live in forest areas of India. And accordingly, you should note that in the year 2006, the Forest Rights Act was created. And it recognized the rights of the tribal people in the forest areas. Now, the third principle of the tribal Panchsheel was related to the administration of the tribal areas. So in this regard, the principle states that teams of tribals should be trained in the work of administration and development. Further, introduction of too many outsiders in the tribal territory should be avoided. So the third principle stated that tribals should be included in the administration and the development of the tribal areas. And the entry of outsider in the tribal administration should be restricted or avoided. The fourth principle states that tribal areas should not be over-administered or overwhelmed with multiplicity of schemes. So this principle states that these areas should not be over-administered. And further, there should be limited number of schemes which should be properly targeted for the development of tribal areas. Now, in this regard, you should note that the PISA Act has been created for the extension of Panchayati Raj in the tribal areas. And this act recognizes the community rights of the panchayats of the tribals, and which are different from the normal Panchayati Raj institutions. And the last principle states that results in the tribal area should not be judged by the statistics or the amount of money that is spent. However, these results should be judged by the human character that is evolved. This means that this should be based on the development of tribes and not just by the statistics or the money that has been spent. So these are the 5 principles of the tribal Panchsheel, and these are important for you from the exam point of view. Now let us look at various regulations and the amendments in these regulations with relation to the governance and protection of the Aboriginal tribes of Andaman and Nicobar Island. The first in this line is the Andaman and Nicobar Islands Protection of Aboriginal Tribes Regulation 1956. Now, this regulation protects the tribals from outside interference. It specifies the limit of reserved areas, and it says that no land in these reserved areas shall be allotted for agricultural purposes or sold or mortgaged to the outsiders. So this shows that the land of the tribal areas cannot be given to other people or the outsiders. Now the second is the policy of non-intervention, which was recommended by an expert committee of Supreme Court in the year 2003. Now this committee was set up by the Supreme Court based on a petition which was filed in 1999, and this petition demanded that there should be mainstreaming of the Jarawas tribes which have been living an isolated life. However, the committee recommended the protection of Jarawas from harmful contact with outsiders. It also recommended preservation of their cultural and social identity. Further, it recommended the conservation of their land and advocated sensitizing settlers about the Jarawas. So this means that the Supreme Court appointed committee had recommended the policy of non-interventions. So this was another policy towards the Andaman and Nicobar tribes. Now in the year 2005, the Andaman and Nicobar Regulations 1956 was amended. And this amendment increased the term of imprisonment and the fine in case of violators. Now further, the Andaman Nicobar Regulation was amended in the year 2012, and it recommended a creation of buffer zone which was contiguous with the Jarawa Tribal Reserve. And in this buffer zone, the commercial establishments were prohibited and the tourist operations were regulated. So these are some of the policy and the regulations related to the protection of Andaman and Nicobar tribes or the protection of Aboriginal tribes of Andaman and Nicobar. Further, the author has highlighted two conventions of the International Labour Organizations or ILO which are related to the tribal communities. So in this line, the first convention is of the 1957 and which is the Indigenous and Tribal Populations Convention 1957. So this convention states that tribals should be integrated into the mainstream communities. However, the 1989 convention of ILO insisted on a policy of non-interference, which means that the lifestyle of the tribal communities should not be interfered by the mainstream communities. And this convention recognizes the aspirations of tribal peoples to exercise control over their own institutions, ways of life, and economic development. Now, in this regard, you should note that India had ratified the 1957 convention, but it has not ratified the 1989 convention. Now, in this regard, the author highlights that although India has not ratified the 1989 convention, it has abided by the policy of non-intervention, and which is visible in the various regulations which are related to Andaman and Nicobar Island, and further by the recommendations of the expert committee which was created by Supreme Court. Now, after going through various regulations and the policies towards the tribals, now let us understand the various issues that are being faced by the tribes of Andaman and Nicobar despite the implementation of these policies. So in this slide, the author has highlighted that there has been poor implementation of all these regulations and policies. Now the author has further highlighted the poor implementation of various provisions and policies towards the tribes of Andaman and Nicobar. In this regard, the author has highlighted that despite the provisions of the Andaman and Nicobar Protection of Aboriginal Tribes Regulation 1956, there continued to be a constant interaction between the tribals and the settlers or the outsiders. Further, the author has highlighted that in spite of the 2005 amendment in the ANPATR 1956, videos of commercial exploitation of Jarawas in the name of human safaris were widely reported in media. Further, it has been highlighted that despite amendments in the ANPATAR in 2012, there continues to be numerous reports of civilian intrusion into the Jarawa Tribal Reserve. Further, it has been highlighted that the lifestyle and dietary habits of the Jarawas has been drastically changed after the creation of the Andaman Trunk Road. And regarding this road, you should note that it cuts right through the Jarawa Tribal Reserve. And the construction of this Andaman Trunk Road has endangered the Jarawa tribe and has also disturbed their ecological balance. Further, it has been highlighted that in the case of Jarawas, this has led to the spread of diseases, sexual exploitation, and begging. And finally, the relaxation of the restricted area permit. And you have learned about the restricted area permit in the DNS of 22nd November. So in this regard, the relaxation in the restricted area permit could have an adverse impact on the indigenous population in the long run. And further, the commercialization of tribal spaces could lead to the encroachment of land. So these are the various problems that have been highlighted by the author regarding the poor implementation of the provisions which are related to the tribes of Andaman and Nicobar. So highlighting these problems, the author says that government needs to reorient its policies and priorities towards the protection of indigenous tribes. Further, India needs to sign the 1989 Convention of the International Labour Organization. Further, efforts should be made to sensitize settlers and outsiders about the rights of the tribals. So these are few points which have been highlighted by the author, and these can be directly used in answers related to various provisions of the Andaman and Nicobar tribes. Now, after going through these points, you should try and answer this question from your mains examination point of view. And with this, let us move on to the next article. Now, this article on page number 8 appears in the context of the recent rift between the RBI and the government. In this regard, this article analyzes two important issues which are related to the relationship between the RBI and the government and about the relationship between the RBI management and its RBI board. So let us look at these two aspects, that is the relationship between the RBI and the government and the relationship between the RBI and the RBI board. So this part of the RBI will fall under the General Studies paper 2 under the topic regulatory bodies. This is because this is related to the regulatory functions of the RBI. And in this regard, you can consider this question from your mains examination point of view, and the points that we will discuss under this article will be helpful in answering this question. Now, the author has highlighted two aspects of the Reserve Bank of India's autonomy. In this regard, the autonomy of RBI includes the autonomy as the monetary authority of the country and its autonomy as a regulator. So in this regard, the author has highlighted that the recent change in the monetary policy framework through the setting up of Monetary Policy Committee has given autonomy to the RBI as a monetary authority. So in this regard, you should note that in the Monetary Policy Committee of India, there are 3 members of the RBI. Plus, there are 3 external members which are recommended by the Government of India. And the governor of the RBI is the ex officio chairman of this committee. And in this committee, the decision is taken by a majority. However, the governor of the RBI exercises a casting vote in case of a tie. So due to the formation of this Monetary Policy Committee, in which the RBI has the dominant power, the autonomy of the RBI as a monetary authority has been restored. However, the author highlights that the mandate of RBI as a regulator is broad and vague, and the autonomy of RBI as a regulator is blurred. So now let us look at the relationship between the RBI and the government. Now, regarding the relationship between the RBI and the government, the Section 7 of the RBI Act provides for a legal framework for the nature of relationship between the RBI and the government. Now, this section enables the government to issue directions to the RBI in public interest. And you should note that in spite of this enabling provisions in the RBI Act, the government has not issued any direction so far. However, the author highlights that there have been certain instances in the past when the government has had its way without even invoking the Section 7. So let us look at one of the examples of government having its way without invoking the Section 7. So in this regard, the author has highlighted an example in which the former RBI governor, Mangal resigned in 1957 due to differences with the government. So in this regard, the government had clearly stated that the monetary policies of the RBI must necessarily be dependent on the policies pursued by the government. So in this case, the government did not have to invoke the Section 7. This is because the RBI governor had already resigned due to these differences. And in the present controversy, in which you should note that the government had ordered the RBI to transfer its surplus reserves. So in this case, the government has desisted from invoking the Section 7, or it has not invoked the Section 7. So the author says that it is a wise move since it would have impinged on the RBI's autonomy and would have sent out wrong signals both at home and abroad. So you should note that the relationship between the RBI and government is governed by the Section 7 of the RBI Act. However, it has not been invoked since independence. Now let us look at the relationship between the RBI management and its board. Now first of all, this debate has started because of the contentious issues between the government and the RBI were sometimes referred to the Central Board of Directors of the RBI. Now regarding the Central Board of the RBI, you should go through the DNS of 12th November 2018 to understand it better. Now let us look at some of these contentious issues between the government and RBI, which the government has referred to the Central Board of Directors of the RBI. Now some of these contentious issues have been related to the transfer of surplus reserves, about which you have studied in the past DNS. It has also been related to the setting up of Independent Payment Regulatory Board. Further, it has also been related to the lifting of the prompt corrective action on the public sector banks. in order to improve the growth scenario in country. So these are some of the contentious issues between the Government of India and the RBI, and these have been referred to the Central Board of Directors of the RBI. So now the debate has started between the powers and authority of the RBI management and the RBI board. So now the debate that has started is that can the board of directors compel the governor of the RBI to act according to the majority view of the board of directors? So in this regard, the author says that according to the interpretation of the Reserve Bank of India Act, both the central board and the RBI governor enjoy concurrent powers in almost all the matters. However, some of the members of the central board are nominated by the government from various fields including the private sector. And due to the entry of the members from the private sector in the central board of RBI, there can be a conflict of interest as the decisions taken by the RBI could directly affect the interests of the private sector members. Now, highlighting the example of United States of America, the author has highlighted that the Federal Reserve System in the United States takes decision through the voting of the board if it finds it necessary. However, regarding the nature of relationship which has evolved over a period of time in India, the author analyzes that the board has by and large played an advisory role. So the role of the board of RBI has largely been of advisory nature. Now, although the role of board has been advisory in nature, the author suggests that the RBI governor must take into account the advice tendered by the board and it should get reflected in its action. So concluding, the author says that overall the nature of relationship between the government, RBI and between the RBI management and its board must be based on the spirit of accommodation and mutual trust and respect. Now, after going through the points that have been mentioned in this article, you should try and answer this question from your mains examination. And in this, we have learned about the relationship between the government and the RBI management and its board. And what are the various issues involved in this relationship. So you should try and incorporate all these points in answering this question. With this, let us move on to the next article. This article on page number 8 is related to a field survey which has been conducted in the state of Jharkhand. And it is regarding the implementation of Pradhan Mantri Matritva Vandana Yojana. Now, this study suggests that the government's maternity benefits must be implemented better and should comply with the National Food Security Act of 2013. So, this will form a part of the General Studies Paper 2 of the mains examination under the topic Welfare Schemes for the Vulnerable Sections. Now, the basics of the Pradhan Mantri Matru Vandana Yojana become important for you from preliminary examination point of view. So, you should go through the basics of the PMMVY from the PDF link of this video. However, in this article, we will try to understand how the implementation of PMMVY has violated the principles of National Food Security Act of 2013. And we will also look at the other problems faced by the pregnant women in the state of Jharkhand. And what are the suggestions provided by the author in this article. Now, let us look at the manner in which the PMMVY violates the principles of the National Food Security Act of 2013. And regarding the National Food Security Act, you should note that there was a question in the preliminary examination in the year 2018. So that is why you should also go through the basic provisions of the National Food Security Act of 2013. Now, under this National Food Security Act of 2013, every pregnant woman is entitled to maternity benefits of Rs 6,000. However, the PMMY violates the NFSA on 3 grounds. The first is that the benefits under this scheme have been reduced from Rs 6,000 to 5,000 per child. The second is that they are now restricted to the first living child only. And the third provision that violates the NFSA principle is that they are further restricted to women above the age of 18 years only. So these are the 3 ways in which the provisions of the Pradhan Mantri Matru Vandana Yojana violates the principles of National Food Security Act. This is because the amount that was sanctioned under the NFSA Act of 2013 was Rs 6,000. And it was not just restricted to the first child, but was also given to other child deliveries as well. And further, there was no age limitation for women in the National Food Security Act of 2013. Now, the author highlights that the Pradhan Mantri Matru Vandana Yojana largely defeats the purpose it was supposed to serve. This is because it excludes more than half of all the pregnancies because of provisions like restriction to the first living child and to the women above the age of 18 years. And this is because 43% births in India are only related to the first child. However, the remaining 57% are related to the second childbirth and which are not covered under the PMMY. Further, the author says that less than half of the women meet the PMMY eligibility criteria. Among those who are eligible, A little over half have only applied for the maternity benefits. This means that the reach and the awareness regarding the PMMY is very low. So these are some of the concerns that have been raised by the author according to the study which was conducted in the state of Jharkhand. Further, the author has highlighted other problems which are related to the Pradhan Mantri Matru Vandana Yojana. Now, the other problems that are related to the Pradhan Mantri Matru Vandana Yojana are that the application process is cumbersome and is exclusionary in nature, which means that due to the difficult application process, a lot of beneficiaries are excluded from the benefits of this scheme. Now, this process includes a separate form has to be filled. It has to be signed and submitted for each of the 3 installments which are given during the Pradhan Mantri Matru Vandana Yojana. So there is a separate form for all the 3 stages. Along with it, a copy of the applicant's mother-child protection card, her Aadhaar card, her husband's Aadhaar card, and the details of a bank account linked to her Aadhaar number have to be provided. So due to the multiple documents that are to be provided, it becomes difficult for the beneficiaries to access the benefits of the Pradhan Mantri Matru Vandana Yojana. Further, the author has highlighted that women in the state of Jharkhand face lack of funds. And due to these lack of funds, they sometimes borrow money to meet their expenses. And in this regard, the author has highlighted that the Pradhan Mantri Matru Vandana Yojana, if implemented properly, could help these poor families from these financial contingencies. So finally, it has been highlighted that the provisions of the maternity entitlements under the National Food Security Act are very important for women who are not employed in the formal sector. And this entitlement is important because this helps the pregnant women in accessing better nutrition during the times of pregnancy. The article, however, highlights that the PMMY undermines this provision of the National Food Security Act due to the dilution of the entitled amount, which has been reduced to only Rs 5,000. And the exclusion criteria, this is because the benefits are limited only to the first living birth. Further, it has been highlighted that there is urgent need for better implementation as well as for compliance of the scheme with the National Food Security Act 2013. And also the maternity benefits should be raised to Rs 6,000 per child, at least for all the pregnancies and not just the first living child. So these are some of the suggestions provided by the article related to the improvements in the Pradhan Mantri Matru Vandana Yojana. With this, let us move on to the next article. Now, these articles on page number 1 and page number 13 are related to the GDP back series data. So in this regard, the data is not very important for us from exam point of view. However, what is important is the trend of the GDP from exam point of view. For example, in the year 2011, there was a question related to the growth rate of GDP trend for the last 5 years in that year. Now, the GDP back series data was covered in the month of September in the Focus magazine. So we'll try to understand the basics of the back series data from the Focus magazine of September 2018. And we will also look at the trend of the GDP data for past 10 years. Now we should note that in the year 2015, the base year for the calculation of GDP was changed from year 2004-5 to the financial year 11 and 12. So the base year for the calculation was GDP was changed in the year 2015. Now whenever a new series of GDP is introduced with an updated base period, it is an accepted practice to link the old series to the new series to provide a comparable set of national account statistics for the users. Further, there was another change that was done in the year 2015. And in this change, the GDP at factor price calculation was repealed with the gross value added at basic prices in the new calculation. So this gross value added at basic prices means that GDP at market price for the base year. Now simply the GDP at market price reflects the market value of all the goods and services produced within the boundary or the geographical boundaries of a country. Now when the GDP at market price is calculated, the market price of a product includes the cost of production plus the indirect taxes that have been levied on that product, and the subsidies that have been provided by the government are subtracted from the actual price. Now whatever is the cost of production for the producer, it is known as the GDP at factor price. So in this case, the GDP at factor price will be GDP at market price minus indirect taxes plus the subsidy. Now why is there a need for back series data? So simply the back series calculations are always done to link a new series of the national income accounts with an old series. And this gives us a better comparison of the growth period of the past years in the new methodology which has been adopted for the calculation of GDP. Now this calculation of GDP back series data has created a political controversy. Now when the data was released in the month of October, it revealed that the Indian economy had grown at a much faster pace than what was earlier estimated during the UPA 1 and UPA 2. However, the new data which has been released today shows that the growth during the times of the UPA 1 and UPA 2 was actually lesser than what was estimated at that time. And the new data shows that the GDP growth never crossed the 9% mark. However, the data which was released in the month of August revealed that the Indian economy grew by more than 10% during the 2006 and 7 years. So that is why it has created a political controversy. So what you need to understand is that there are two changes in the method of calculation of GDP. The first is the change in the base year for calculating GDP, and the second is the way in which the new GDP is being calculated. That is, the GDP at factor price has been done away with, and the new method uses the gross value added at market prices at the base year, that is 2011-12 market prices. Now, whichever method is used, more or less the trend of the GDP growth remains the same. So if you go through this graph, you will find that the GDP dipped in the year 2008 and 9. Further, it dipped in the year 2011 and 12. And it has again started decreasing after the year 2016 and 17. And now if you go to the question which was asked in the year 2011, it reads, in the context of Indian economy, consider the following statement. The first statement reads that the growth rate of GDP has steadily increased in the last 5 years. Now this statement was incorrect because, as we have seen, the GDP dipped in the year 2008 and 9 because of the global economic recession. Further, the second statement reads that the growth rate in per capita income has steadily increased in the last 5 years. Now this statement was also incorrect. That is why the correct answer that came out was D, that is neither 1 nor 2. That is why the trend of GDP growth rate becomes important for us from exam point of view. And with this, let us move on to the next article. This article on page number 7 is related to an observation of the High Court in the case of 1984 riots. And in this, the High Court has observed that the present criminal justice system, including the laws and criminal procedures, is inadequate to deal with sensitive issues such as riots. And in this, the High Court has suggested that the investigative process should be entrusted to authorities other than the normal agencies. So the High Court has suggested that the investigative process should be taken away from the normal police and should be handed over to other authorities. So this will form a part of the General Studies paper 3 under the topic security. So under this article, we will try to understand some of the key observations of the Delhi High Court and the various suggestions provided by the Delhi High Court in handling the cases related to the riots. Now, the first observation of the High Court has been related to the political influence in the cases of riots. So in this, the court has observed that in each event of communal riots, there have been instances of political influence in saving the accused. So the High Court says that for cases of communal riots, which at times are engineered for various purposes, needs reforms at the investigation and the prosecution stages. So due to the dominant political influence in saving the accused of the riots, the court has suggested that there should be reform in the investigation and the prosecution processes. Further, the High Court has stressed for the need for neutrality on gathering evidences and has suggested that there is a need for neutral investigation and prosecution for serving the justice in a non-partisan way. Now you should note that the investigation is generally done by the police in the cases of riots. However, due to the lack of police reforms, they are under the control of the state government. And it is in this regard that several politicians in the government try to influence the investigation of the police in cases of riots, as observed by the court. So in this regard, the court has observed that there is a need for neutral investigation. Further, the court has observed that the evidences collected by the press reports, which are supported by photographic material or video footages in trials of criminal cases, both by the print media and the electronic media, can be used for a fair trial of such cases. Most of the times, the news reports and the video footages are not considered as evidences in the cases of riots. So the court has observed that such reports and videos or the photographs should be considered as evidences for the fair trial of such cases. So for neutrality in gathering of evidences, the High Court has suggested that responsibility of gathering evidence should be given to NHRC. So in this regard, the High Court has observed that the initial task of gathering and preserving evidence on such sensitive cases should be entrusted to the Human Rights Commission to ensure neutrality. Further, the High Court has observed that once a commission of inquiry is instituted under the Commission of Inquiry Act 1952, the process of gathering all the evidences of such cases should be taken over by such commissions of inquiry. And in this case, it has suggested that the Human Rights Commission should do so. Further, you should note that Human Rights Commission is just a statutory body and is not a constitutional body and is constituted under the Protection of Human Rights Act 1993. So the High Court has suggested amendments to the Commission of Inquiry Act 1952 and the Protection of Human Rights Act 1993. The responsibility of investigation in communal rights can be handed over to the NHRC as against the present practice of collection of evidence by the police, which can be easily influenced by the politicians who are under the government. Now, this is just an observation and can be used in answering questions which are related to communalism and riots in the mains examination. However, this is a news in transition and let us wait for the government to bring out a law on this issue. With this, let us move on to the next article. Now, this article on page number 9 is related to the impact of change in the crude oil prices on the economy. Now, this has been discussed in detail in the Daily News Simplified of 28 November 2018, that is yesterday. However, only additional thing that you should understand is that the Indian basket of crude is represented by the weighted average of the prices of the Dubai crude oil, the Oman crude oil and the Brent crude oil. And this index of weighted average indicates the price of crude imports for India. So along with this, you should go through the DNS of yesterday to understand the impact of change in crude oil prices on the Indian economy. Now, if you go through the previous year question that was asked in the year 2011, it reads, in the context of global oil prices, the Brent crude oil frequently referred to in the news. What does this term imply? So in this case, the first statement, that is, it is a major classification of crude oil, is true. The second is that it is sourced from the North Sea, is also correct. So the correct answer in this case was B, that is 1 and 2 only. So here you should note that Brent is a term used for the oil that is extracted from the North Sea. And the location of North Sea is visible in this map here. And we note that it is located near England. Now this editorial on page number 8 is related to the decreasing trend of the non-performing assets of the banks. Now the basics of the gross NPA and the net NPA and the slippage ratio have been discussed in the yesterday's Daily News Simplified. So you should go through that video to understand the basics which are important for us from preliminary examination point of view. And with this, we have come to the end of today's discussion. Now let us move on to the question for the day.